It is a great honor for me to introduce our first speaker of the day, someone that I know when I go to the AAJ conventions and seminars, when his name is there, I'm going to be in the room. And that, of course, is Howard Nations. Howard specializes in pharmaceutical litigation, catastrophic injury, and wrongful death cases. He's board certified by the Texas Board of Legal Specialization as both a personal injury attorney and a civil trial attorney. But we all know him because he is nationally recognized for his trial work. He is the former chair of AAJ's NCA. He's a trustee of the American Jury Foundation and past president of the Bell-Eye Society. And the Bell-Eye Society, if you haven't participated in that, you really should think about it. I spoke at their presentation at the last AAJ seminar, and it's a terrific day. He also serves on AAJ's executive committee as vice president. He has been vice president, secretary, and treasurer. He's a diplomat of AAJ's NCA, and he has spoken in all 50 states and internationally. I can either go on and on and on and tell you all of the tremendous accomplishments of Howard Nations, or I could just ask him to please come up and speak to you himself. Thank you very much.
Good morning. One of the most significant things that's happened in my career has been my connection with Dave Winter and my connection with Lisa Blue, two of your speakers here today. I've always been fascinated with how the human mind works, the decision-making process. And when I was in the process of studying this, I ran across Dave, found his work to be fascinating, and Dave and I started giving speeches together. And we do a one-day seminar on psychological principles and applying psychological principles to trials, and we've spent a lot of time, along with other people, trying to figure out just how does all this forensic psychology work into the trial of a lawsuit. Dave called me some time ago and said, "What's up? What are you doing?" And I said, "Well, right now, I'm in trial in a legal malpractice case as a lawyer, not the defendant. I'm preparing a mass tort case in Judge Weinstein's court in Brooklyn, and I'm preparing a catastrophic injury case, brain injury, wrongful death case in Arkansas. Aside from that, pretty much free." We talked about the fact that those three cases, as different as you could possibly be, I was defending a legal malpractice case for a friend of mine. I was bringing a mass tort case on behalf of 950 plaintiffs, and we were getting ready to try the bellwether cases in Brooklyn. And I was getting ready to try a multiple brain injury, several parties, and wrongful death case in Arkansas. And we talked about the fact that what do those cases have in common? And are there principles that apply to each of those cases, even though they are very different cases? And even though I'm defending one and plaintiff on the other two. So what Dave asked me to do here today is to talk to you about how do you deconstruct a case? How do you prepare a case for trial, taking those principles that we've been talking to you about for years? How do you actually use those principles while you're getting ready for trial? And how do you use them in preparation? How do you use them in trial? Where do they really come into play? So let me begin with this. With me, every lawsuit begins with law. Before I get into any case of any type, I always start at the end and work backwards. I want to know what the court's charge looks like. I want to see the charge because I want to see the verdict form. I want to see the questions that the jury is going to be called upon to answer, because my job is to provide those answers. So I want to think about the jury question first, the verdict form. Then I want to go back and make sure that two things happen. One, my pleadings, and two, my body of evidence fit with the third thing, which is the court's charge in the verdict form. So I always want to know the law. I always want to know exactly what's my burden of proof in this particular case. And I want to know what the defenses are that I can anticipate, and I want to know what how can I deconstruct the defenses. Now, taking it from the top, the way we evaluate cases, or the way we prepare cases, is we'll start with the first element, it doesn't matter if it's negligence, breach of contract, whatever it is. But we work from a body of evidence. So we'll put I love those big sticky pads that, I mean the big ones like this. You write on them, you stick them up on the wall. We've got a pretty good sized war room, and we end up with these things stuck up all the way around the wall. And here's how we do this. We start with, I'll take the element of negligence. Now, under negligence, we want to take all the evidence that we have, and here's how we evaluate it. You want to look at just on the issue of the negligence of this particular defendant. I want to know, number one, what is the documentary evidence that I have supporting this? Because that's the least changeable. Witnesses change on you. Documents don't usually. They sometimes do, but I want to know documents. Secondly, I want to know lay testimony. On the issue of this negligence of this defendant, what is every piece of lay testimony I have? Precisely who is the witness, and precisely what is this witness going to say about the negligence of this defendant? Then I want to know about expert testimony. Do I have expert testimony with respect to the negligence of this defendant? Who is it? What are they going to say? Is it a hired gun expert that the other side's going to hire one that's just going to offset them and the jury's going to ignore both of them? Or is this an expert that came up in the case naturally? Then I want to know about demonstrative evidence. What demonstrative evidence do I have? All the various types of demonstrative evidence. Photographs, any type of graphics, medical records, anything we can show a jury, visual evidence. And then I want to know the fifth thing is, what are all of the pretrial pleadings that we have that are useful now on the issue of negligence? Request for production, request for admissions, deposition testimony, anything we have that's already part of the record that we can use on this issue. Now, when we put those things up on the board, and we'll have all those up there, and that's just on the negligence of this defendant. Now, that is our body of evidence. That's the body of evidence as it stands right now on this defendant on this issue of negligence. We then go through the process. We start with the next issue, which is causation. And on causation, we do the same thing. That's where we can lose our cases. So we do exactly the same analysis on that. We go through documentary, lay testimony, expert testimony, the demonstrative evidence, and then pretrial evidence already in the record, already part of our record. Then we get to the issue of damages. Now, I think damages is where we fail our clients the most. We seem to think that damages follow naturally. If someone's injured, that everybody's going to see it, and damages follow naturally. So let me suggest to you how you approach damages. I taught damages in law school for 25 years. I've been trying damages cases for 45 years. So I know a little something about it. On the issue of damages, think in terms of each element of damage as being separate and distinct. Physical pain. The defense would love for us to talk in terms of pain and mental anguish, as if it's one element of damage, as if that's all one thing. It's not. Physical pain is an element of damage. It should have its own body of evidence. You should have an entire body. I'm being repetitious on purpose. You should have an entire body of evidence on physical pain. Then you move to mental anguish, and you do an entire body of evidence on every aspect of mental anguish. You know how many different types of mental anguish there are? How many different elements? All the fear and the pain that naturally the anguish that naturally accompanies pain, things of that nature. But if you do this same analysis, we put pain up on the wall. We put it up on the board, and it will say, okay, everybody we have, every witness we have who can testify to the pain of this plaintiff. And you know who quite often one of your best witnesses on that will be? It'll be the defendant who was at the scene, who witnessed the pain. And you think of how can you call upon this defendant to testify to the pain, to the suffering of the plaintiff that they saw at the scene. Because if you had prolific pain and suffering obvious, then you put them in a position where they either have to verify it, testify to it, or they have to be caught sort of by the jury sort of brushing it off as if it didn't exist. So they're in a no-win situation on it. But you want to know every witness who can testify to physical pain. You want to look at your therapist, your doctors, your nurses, the family members. The last person to testify, the person who's the least reliable on pain, is the plaintiff themselves. You don't want a whining plaintiff, but you want all these other people. Then you look for documentary evidence of pain, the document, the medical records. I have a lawyer who's been with me for 25 years, and she's also an RN. And she went through a medical record for me on one occasion, and I said, I want you to go through here and I want you to find all the pain, all the evidence of pain that you can find. Well, the guy I was having trouble because my plaintiff was this big old guy who was a construction worker in Houston who had been, he was on a motorcycle. He came flying down a road one day on a motorcycle riding home, and they had just put down fresh asphalt on this road, and when they left at the end of the day, they forgot to put up the barricade. And he's the first guy to come along, so he comes along, he hits that front wheel hits that asphalt, and it flips over and over, and it tosses him over, and it throws him on his back, sliding across that fresh asphalt, and it becomes completely embedded in his back and in his buttocks, and it was, deeply embedded. And then, to top it off, his bike spinning over and over fell on top of him, broke his leg, and he's caught under it. This was not enough. The woman in the car behind him sees what's happening. She pulls up, and she testifies she thought she'd hit him because she came up so that he's on the ground, he's flat, and her front bumper is like right here over him. And then the gas cap pops off, and he's smelling gas. And, think about it. Do your analysis of pain, mental anguish, fear of burning to death, fear of so many things. So you take something like that, and you deconstruct it into every possible aspect of pain, every possible aspect of mental anguish, all the real, honest God fears that he experienced. But he was a big, burly guy. This guy thought John Wayne was a sissy. And he would never, ever testify to pain, ever. He wouldn't say, I hurt. Not that big a deal. So I had Carolyn go through this record for me, and she said, oh, here, betadine X2, betadine scrub X2. She said, that's pain right there. Really? Okay. explain it to me. She said, let's go talk to the nurse. So I get the nurse. Well, the nurse ends up testifying that, yes, I had to do a betadine scrub. And what a betadine scrub is, I'd have to go in with this guy, and I would have to take tweezers, and I'd have to dig down into his back and pull out that asphalt. And then I'd have to scrub him down with this betadine. And said it was horrible. So, well, how did he react? Said, well, it was so bad, said I could only do a small section of his back at one time, then I'd have to, because he could only take so much at a time. And we had to wrap up a washcloth and put it in his mouth so he wouldn't scream out and scare the other residents of the hospital. And I said, well, how did he react when you did this, when you went in digging in to pull these out and then put the bed in? She said, oh, he cried like a baby. Okay, that's evidence of physical pain about a guy who would never use the word pain in the same sentence with himself. But that came out of that's just a medical record. That's just going over your medical records, seeing what you've got, and offering your proof. So, you do physical pain. Now you take the next thing, mental anguish, then you take physical disability, take physical disfigurement, take damage to wage earning capacity, all your elements of damage, and each one gets its own body of proof, a complete body of proof. It's a terrible situation to find yourself in these days, particularly with the appellate courts that we have, reviewing records, to go in and you make a great closing argument and you move the jury emotionally and you get a verdict, and then that cold feeling when you start looking through the court record to find your evidence of damages. Oh, the evidence of damages, that's over here in the closing argument. Wasn't I brilliant? No, you weren't all that bright because you didn't put in any evidence of damages. So, think in terms of creating a complete body of proof with respect to every element of damage and with respect to your negligence and with respect to causation. Separate body of proof. Then the fourth thing that we look at, negligence, causation, damages, the fourth thing is we then deconstruct defenses. We take the defenses that we know are coming, and we put them up on the board, and we say, okay, now what are they going to do here? What is their position? And I had a retired defense lawyer with me for a long time, and I would give him the job of being the defense lawyer. And I'd say, okay, I want you to go into this case, and I want you to come at me as hard as you can, exactly the way you would if you were defending it. And then we would go in and we'd look at their defenses, and then we think in terms of what is our counterpoint to that? How are we going to oppose those defenses successfully? We'll talk to you a little bit about when you get this body of evidence, what you've got right there is this is the rough outline. Now you have a rough outline of your story. You know, Jerry is going to talk to you later this morning. Jerry's the first guy I ever heard say it's all about storytelling. Jerry recognized it before the rest of us did. And you got some brilliant people talking to you today. It starts right after I finish. But you've got the outlines of your story. You got the rough outlines of what your story is all about. But then you want to look at your story. I'm going to mention, I don't have time to talk about storytelling except to say this. Look at your story from the first person version of every witness. Instead of looking at what a witness says, write out that witness's version of what happened from the first person, as if you are in that person's position. Write his or her story in the first person as if you are that person. It gives you a perspective that you won't get looking at it from the outside. This is what this witness is going to say. I'm viewing you as a third person. No, I want to be in your position. So if you want to get an insight into the story, look at try to write your story, just try to write it out for your own benefit in terms of, I am the first person, I'm telling the story. Now, in an ideal world, you got the accident, the auto accident took place, you would then go to the corner where that witness was standing when he saw the accident, you would stand where he stood, you would then have his story in the first person, you would see what he could actually see, you could see what he couldn't see, and you would learn a lot more about the other things that he might have added to his story, might know additionally. In an ideal world, you can do that. Now, when you start then thinking in terms of putting these together, the first of the principles I want to talk to you about, the psychological principles, is a tremendous opportunity for us as the plaintiffs to use. It's the availability principle. And the availability principle tells us that the jury will focus in the jury room and their deliberations. They will focus on where you place the spotlight during your presentation. They will focus on what you make available to them, what you choose to make available to them. Now, if you choose to make available to them, you spend your entire case talking about your plaintiff. That's all they have available to them. All they're going to be examining when they get in the jury room is your plaintiff. So the availability bias is critical because we can use it. We're first. We get to decide what we want to make available to the jury. And I call it the spotlight theory. We get to decide where we want to put the spotlight. And as a general proposition, you want to put the spotlight on the negligent conduct of the defendant and the damages of the plaintiff. Now, it is not enough today to try a case in which you simply prove the negligence of the defendant. I submit to you that you have to go further and prove the absence of negligence of your plaintiff. Prove that your plaintiff did the right thing. It's the norm bias. What do you compare it to? Compared to what? Think in terms of compared to what. Okay, the plaintiff's conduct is right compared to rules of the road, compared to what is expected of drivers, compared to what is expected of whatever your plaintiff is. My plaintiff acted properly. My plaintiff did everything right. So the reason is you can't just leave it out there that, okay, the defendant was negligent. That's not enough because there's an anti-plaintiff bias. So if you don't come in and say and show them that my plaintiff did everything right, they will make up stories about what your plaintiff probably did. Well, he probably did this or he probably did that. Trust me, we see it over and over and over in focus groups. So take that extra step and prove that what your plaintiff did was the proper thing to do. They met the norm. Okay? Now, I want to bring up the next of the principles after availability is something very important because we lose a lot of cases on causation. So I want to talk to you about the attribution principles. And the attribution principles are these. It is, what are the principles that jurors use in attributing responsibility or attributing fault, if you will, for conduct? Now, there's a friend of Dave's named Lee Ross, who's a professor at Stanford. And Lee actually has come and spoken at Dave's invitation. He's spoken to at conferences in the past. And Lee came up with the fundamental attribution error. What he discerned was that in placing responsibility, in placing fault, jurors will look at basically they look at three things, but basically two. They'll look at people involved, and they'll look at circumstances, and then they may or may not look at timing, and there's things surrounding timing and so forth, but that's usually not relevant. So basically it comes down to situation versus people in determining what is the reason that this occurred. What is the fault? How is fault placed? They decide, was it people that caused it? Or were it circumstances? Were the circumstances the cause? Here's the error. What Lee says is that the fundamental error is that jurors will err on the side of overemphasizing the situation as being causative and underemphasizing people as being causative. So what we have to do with that is this. They're going to, I'm sorry, I got that exactly backwards. They will overemphasize the conduct of people and underemphasize the situation. What that means is this. If they look at people as being causative, when they're trying to decide what caused something, who's the person they're looking at? They're looking at the plaintiff. So you've got the plaintiff injured in an accident or some type of tragedy, and they look at it and they're saying, okay, did this injury occur as a result of people, the person involved, that is the plaintiff, or did this occur as a result of the situation? They will overemphasize fault on the person, underemphasize fault on the situation. Two ways to use this. The first thing is, remember, you got two people involved. It's okay for them to overemphasize fault on the person so long as the person is the defendant. Now, in looking at whether they're going to place fault on the person, they will look at the individual traits and characteristics of the person. This comes back to another fundamental concept, which is liking the plaintiff, the concept of liking. It is very important that the jury like your plaintiff. It's important that the jury like you. But this is one of the reasons. So when we're talking about our plaintiff, we have to set up the plaintiff not just as an injured party, not just as someone with all these devastating injuries. We have to talk about our plaintiff in terms of their responsibility. They're a responsible person. They're a responsible driver. They're an experienced driver. Whatever it is they're doing, they are good at this. They take responsibility for what they do. They have a lot of experience as a driver. You bring out traits that would make a jury believe that as between the plaintiff and the defendant, the person most likely to have been causative here is going to be the defendant. Because going in, and this is the error part, and this is part of subliminal jury bias. This isn't something that the defense this isn't something the insurance industry created. This is just out there. This is just a psychological principle that's out there that works against us. Just fundamentally, they're going to look at the person and say, gee, you got hurt in an automobile accident? Probably your fault. Okay? So you need to always be building up your plaintiff in terms of their character, their experience, they're doing the right thing, and then attacking the defense on the other side. And this is where the next error comes in, which the next attribution comes in, which is the purposive attribution theory. There's purposive, reactive, fundamental, defensive. There's several of them, but the ones that I want to talk to you about, purposive attribution. Purposive attribution is this. The jury will be very hard on someone that they feel attributed to causation as a result of acting on purpose. Now, on purpose, not intentional. We're not talking about intentional willful conduct. We're just acting on purpose. Someone is driving 70 miles an hour in a 40-mile zone. They are driving 70 miles an hour on purpose, not willfully to injure a plaintiff. They're driving 70 miles an hour because they chose to. They're acting on purpose. Now, the more purpose you can show, the more purposive conduct you can show on the defendant, there gets to be an irritation factor in there. So this comes back into the thing that I worked on a lot, which is choice, the power of choice. I think choice is one of the 2 or 3 most important words we can use in the courtroom these days, honestly. If you show that the defendant chose to act in the way they're acting, the more choices you could show that the defendant could have made that would have avoided the result, the tragedy, the better off you are, the stronger your case is, the irritation factor there kicks in big time. Now, you take a medical negligence case. You show that a doctor had 2 choices. He chose this one over this one. As a result of this one, there's a tragedy. He could have done it this way, and maybe there wouldn't have been a tragedy. That's probably not going to get you there in a medical negligence case, because he's going to come in with all of his friends and expert witnesses who are going to say, no, either one was fine. This is just one of those things that happens, and it wasn't negligence. But here's what you can do. You show that there were 5 different choices. When the patient came in for their evaluation by the doctor, there are 5 different tests the doctor could have. There are 4 tests the doctor could have done. This is an actual case I tried. There are 4 different tests that the doctor could have done. Any one of those 4 tests would have caused the patient to be hospitalized overnight. They could have done this, in which case, ladies and gentlemen, we wouldn't be here. He could have done this test, in which case this would have been found, and we wouldn't be here today. He could have done the same thing, 3, 4. Instead, the doctor chose to send the patient home, where he died in his sleep during the night. So the more choices you can show that the defendant had, which could have avoided the result that you have here, the stronger your case. And it even gets to the point where, if you get enough, it gets to the point of being almost willful. Here's what I think about punitive damages and willful conduct these days. I never try a case anymore on punitive damages. I never try a case on willful conduct unless it's just something blatant like drunk driving. If it's drunk driving, you can try a case. But I don't do it, because for this reason. The appellate courts hate punitive damages. They will do everything they can to set them aside. You're far better off in most jurisdictions. You're far better off to put all that exacerbating evidence in that you can get in. Sometimes you can only get it in if you're pleading punitive damages. But if you prove a lot of choices available to the defendant that would have avoided this, then you're not asking for punitive damages. You're simply using that to increase the irritation factor, which they then apply as a multiplier to your general damages. Put this over here on your physical pain, mental anguish, physical disability, physical disfigurement, the general damages. because the appellate courts are much less likely to tamper with a general damages finding than they are to tamper with a punitive damages award. So, think in terms of purposive attribution. Defendant acted on purpose. Now, the other attribution, reactive attribution. Reactive attribution is that the defense, the jury will tend to forgive conduct, even possibly to the point of negligent conduct, if the actor is in a reactive posture as opposed to a purposive posture. So if you need to stress, especially on comparative fault. You stress the fact that the plaintiff was reacting, whereas the defendant was acting. The defendant, and here's where you come back to fundamental attribution. The defendant chose to act in such a way as to create the situation. So in fundamental attribution, whether they're looking at situation or whether they're looking at person, it's the defendant either way. The defendant chose to act in such a way that created the situation. It's the fact that he was driving 70 miles an hour in a 40-mile zone and decided to made the conscious decision to try to make it through that red light. That's purposive conduct. That created that dangerous situation. On the other hand, the plaintiff, who is being charged with comparative fault for whatever, was reacting. So you want to stress the fact that this reaction, the plaintiff is reacting to a situation created by the defendant. So those are the attribution. There's defensive attribution, which simply says that be cautious about accepting someone on a jury because you think they are just like your plaintiff and they will identify with your plaintiff. A very quick example on defensive attribution, because it's very, very important. Because it's so easy for us we would naturally be misled by it. We'd mislead ourselves by it. The defensive attribution is this. I had a case in which we had I-10 was being built. They were doing some construction work, and they just wiped out the backyards of all these kids. And it was Good Friday, and all the kids were out of school, and there had been torrential downpour. There had just been rain for a solid week, and they weren't working on the construction site. And they were sinking all these big poles where they're putting in the big highways. And they had all these 30-foot pits, and these 30-foot pits were filled with water. And these kids were all out. They're out of school, and their playground is gone. So they're out there playing in the back. On this particular day, it wasn't raining. They're out there playing outside. Long story short, one child falls into the pit. His brother jumps in to save him. Okay? The one child is, the first one that falls in drowns. The second one is brain injured. The mother, and the mothers of all the kids, same situation. The mother is in the house. Kids are playing outside. I did focus groups on this. And boy, did I got a quick education. Immediate response. The men across the board, several of them had worked construction. Men on the focus group were coming up with great ideas about, boy, here's what the construction people should have done. They should have done this, and they should have done this. The women were what? Totally blaming the mom. So we did another focus group. We brought 24 people in. We got 12 women, 12 men, and we made the whole presentation, and then we divided them up into two groups of 12, and we put the men over here, got great feedback. The women over here, men never mentioned the mother, ever. Nobody ever raised an issue on the mother. The women never talked about anything else. Total fault of the mom. Okay, that is defensive attribution. Why are the women doing that? They're doing that because they are defending themselves. A mom, and the more similar a woman is, this is a woman who had 2 children. One was 7 years old, one was 11 years old. And so if you had a woman on the jury who had a child who's 7 and 11 years old, you think, she just might identify with this plaintiff. She might identify with this loss. No. What she's going to identify with is, you know, obviously she did something wrong that caused this. Otherwise what? Otherwise this could happen to me. This can never happen to me and my children. She's defending herself. This can never happen to me and my children because I wouldn't do whatever it is she did. I would not have let my kids go out on that day. Whatever. So that's defensive attribution. So it's a trap. Just be aware of it and watch for it. Power of choice. On the power of choice, what you want to do is you want to look. We always just make a list, and we'll put it up here. We'll say, okay, let's brainstorm it. Give me the defense choices. Every one. Let's name every one of them, and we list them. Now, when we put the defense choices up, we now say, and this is important, as opposed to everything else I've said to you. We now say, okay, now convert this to positive action on the part of the defendant. You don't say the defendant failed to do this, the defendant failed to do that, the defendant didn't do this. You say the defendant chose to do this. You have to convert this to positive action. It has to do with communicating with the unconscious mind and all that, because the unconscious mind does not process negative information. So you want to convert it. So the doctor didn't fail to do this test. He didn't fail to do this test. He didn't fail to do this. The doctor chose to ignore this test. He chose to ignore this test. He chose not to do this. He chose instead to send this child home without proper testing. So convert, when on the power of choice, always convert the actions of your defendant to positive choices. Then you tie your choices back, as we discussed, back to the fundamental attribution. Okay, now when you're now down to the point where you can start thinking in terms of the concepts and how you're going to present this and how you're going to do your storytelling. And what I always try to do is I am a firm believer in focus groups. I've been doing focus groups since 1984. I did my first focus group because I attended a political focus group in 1984. And I watched these reactions and I'm like, wow, if this works for politicians, why wouldn't this work for jurors? If it works for voters, why wouldn't it work for jurors? So we started doing focus groups in 84, and I am a firm, strong believer in focus groups. So I always test my stories. I test my theories, but let me tell you what you always test. Always test your physical evidence. Always test your demonstrative evidence. Always test anything that the jury is going to take into the jury room where they have it with them, where they can take it and look at it and say, wait, look at this. Oh, look, oh, did you notice this over here? Boy, make sure you know what jurors are going to see when they get in there, because they'll see things you can't imagine. So we had a case where we had myself, we had two different plaintiffs, two other plaintiffs' lawyers that were referring attorneys. We had 3 lawyers. We had like 4 people from my firm. And we had looked over and over and over and over at these pictures. And we're looking for what happened big controversy. What exactly happened in this tragic accident that killed a couple of people? And we had looked at it, and a photograph, highway patrolman's photograph, and there were like 10 of them. And I did a focus group, and we're going through the photographs, and we're not telling them, we're just letting them discuss it. And this lady says, and we're talking 3 weeks before trial. I mean, we've had this case for 2 years. This lady says, well, it's obvious what happened. And really, what would that be? And she says, well, let me show you. She takes a yardstick, and she comes over, and she comes up to a screen, and she lays that yardstick on the screen. She said, here's the path right here. And we're like, damn, of course it is. Of course it is. And she was absolutely right. But I had 7 people, lawyers, professionals, looking at it, and we had never seen it. And it's one of those things that once she pointed out, you couldn't miss it. And she was absolutely right. And we tried the case on that theory. So I can't stress to you enough the importance of focusing anything that's going to be demonstrative, anything they're going to take in the jury room with them. Let focus group members take it in the jury room with them and see what they come up with, okay? The next thing, some concepts that I'm just going to mention to you in passing here. Primacy, recency, availability, framing, theming, and sequencing. You think in terms of primacy as, you get their attention. You grab their attention with the first thing you do. And you think in terms of, they pay closer attention, obviously, when you first begin something. So you use the concept of primacy absolutely everywhere. In every examination of a witness, you start with, your primacy should be, what am I going to start with? In your cross-examination, if your cross-examination begins with, now did I understand you to say, did you just testify that, the jury's saying, yeah, that's what he said, we heard it. No, primacy, go in and make your point. Have a point to make. That's primacy. Recency is you leave them with you close with a strong point. You do that on every witness. You do that you do it before every lunch break. You want the last thing they hear before they leave for lunch to be strong. That's recency. You want the first thing they hear after they come back from lunch you want to capture them again. So that's primacy. You want to start with that. And you certainly want to leave them at the end of the day with something strong, because thinking in terms of when they go home tonight and the spouse says, what'd you do in court today? Well, we did this. You want to leave them, you want to know what you want that to be. You want it to be your theme, and you want to make sure that they are your trial story, and you want to make sure that they're buying into it. Now, framing, how you frame questions is important. That's why you see all these stupid political polls. I mean, they're not stupid, they're smart. The people that believe them are stupid. You tell me what you want the answer to be, and let me frame the question, and I'll get you the poll results. I mean, that's what pollsters do. So think carefully about how you frame your issues, how you frame your question. Sequencing is extremely important. You've got to you're telling your story now, but you have to think in terms of sequencing it. In what order do we present this? You want to, and putting that in with primacy and recency, you want to start strong. But do you want to, I always think in these terms, what is your outcome determinative issue in the case? It doesn't matter what my damages are if I lose on causation. It doesn't matter what my damages are if I don't carry this point on it being a defectively designed product. If I don't carry defect, nothing else matters. So I want to know what is my, or if I got a clear case of liability, then my big issue, my big outcome determinative issue, outcome in terms of the amount of the verdict, what's the issue going to be? What is the element of damage that's going to be the most outcome determinative? So that's where you want to think in terms of sequencing. You want to sequence in such a way that you make sure that you're putting the most important things exactly where you want them to be. If you need to sequence, for example, you need to sequence your evidence in terms of establishing liability. If it's not a clear case of liability, you need to establish your liability first before you start talking about your damages. Because if you put on all, you come in and you say, I got a strong damage case, I'm going to hit them with damages. I've heard this phrase, the damages will carry the liability. Not anymore, it won't. Maybe it would have. And if it will in your jurisdiction, call and let me come try a case there. Because damages don't carry liability anymore. Tort reform has I think, largely wiped that out. So you have to carry liability. But if you come in now and you start proving up damages in sequence ahead of liability, then they're sitting there wondering, okay, they're wondering, first of all, why am I hearing this? Because what's that got to do with the guy sitting over there at the defense table? And secondly, you're playing right into the preconceived notion that they have of plaintiff's lawyers coming in there trying to, you're just going to come in here and try to move me. You're going to come in here and try to persuade me. So we have to go in and sequence in such a way that we establish, they have to know why. They have to know why they're hearing damage proof. So you have to come in strongly with your liability proof. Once you've got your liability proof, now, sequencing your damages, I think it's best to, there's a thing called the Zeigarnik effect, which is that we have a tendency to believe and cling to tenaciously that which we discover on our own. So I don't come in at the beginning of a case and on voir dire examination or on opening statement and lay out what an extremely devastating, tragic case this is. I want them to discover this on their own. I want it to be their idea. So I don't talk in opening about this being a permanent irreversible brain damage that will plague this poor plaintiff forever. No. You talk about a head injury. You start out talking about a head injury. And then you move on into a little stronger language. And after your neuropsychologist or your psychologist or your surgeon, after they testify that this is irreversible, permanent brain damage, it's going to be this way, there's nothing we can ever do, let them hear it from the doctor. Let them discover on their own. You want their thought process to be, oh, this is a head injury case. Oh, this is a serious head injury case. Wow, this is a very serious. Wow, this is a devastating case. Gee, this is a horrible tragedy. So that's all part of sequencing. Sequencing is pretty crucial. The next thing is just communication skills. Every case, we always look at the language of the case. We have a separate section in our trial notebook called Language of the Case. And what we have in that case, what we have in that list, are the particular words and phrases, terms of art, terms of science, that apply to this case, that are peculiar to this case, and we're going to have to think of the best way to convey those words to the jury, to make the jury understand those words, or that have a normal meaning, but they have a different meaning in this case, or they have a normal meaning that has several different interpretations possible, and we have a particular interpretation we want to make sure that they understand. So we always think in terms of the language of the case, and then we try to capture in that language of the case, we try to put our catchphrases. And the catchphrases are you take those difficult words. I'll tell you a real quick example. I tried a case a long time. I find myself saying this a lot. I tried a case a long time ago where a lady went into like a Walmart, and she reached down on those. You see those tiered candy stacks, and they have just cellophane and candy everywhere. Okay, everywhere they can put one. Well, she reaches down on the bottom shelf to pick up a bag of candy. And as she does, she impales, you know those sticks that stick out that have the extra bags on them? She impales her eyeball on one of those, and as she stands up, her eyeball pops out. And she's blind. Yeah, me too, I thought that. So I'm trying to think, okay, they're called shelf extenders. Okay, now the term shelf extender doesn't execute the required level of emotion as recommended by Aristotle. So I'm trying to think, what would be the right thing to call that? So I'm taking the guy's deposition who loads those shelf extenders up for a living. And I said, by the way, what do you call those at the company? He said, oh, we call those profit pegs. Is that the perfect catchphrase? Because back then, my theme was profit over safety. That was the theme of the case. This is a case about profit over safety. So they called them profit pegs. So that's the kind of catchphrase. That's the kind of catchphrase you're looking for. Then finally, you bring it all back around. One last mention on your demonstrative evidence. Your demonstrative evidence, you start with what you have. And I will tell you that photographs quite often are the most powerful we have all, I mean, hell, I'm guilty of it. I'm as guilty as anybody of animations. I spend a fortune on all that stuff. But a lot of times, some of the best evidence I have ever put in have been a simple family photograph. So start with what you have. Then you look at what can I do to improve that? What can I do to make it more presentable? Blow it up, put it on a stand, whatever. X-ray, turn it into a positive, whatever. How can I improve it? The next thing you look at is you put all those up there, and what am I missing? Are there any blanks? Now, what do I have to create? What do I have to create in order to tell the entire visual story? Because you're telling a visual, verbal, and nonverbal story. So think about that, and it all comes back to, full circle back to, is what I'm putting together here, is that getting the answers I want over here to that verdict form? That's what it's all about, is coming from, that's why all lawsuits begin with law and hopefully end with deposit slips. So I hope I've said something that will help you help your clients. Thank you very much.